that has
Good afternoon. I am Masiga Morris. Thank you for joining us for the anti-money laundering webinar and its impact on the legal profession. Mr. Chacha Odera will be moderating the discussion for today. Mr. Chacha Odera is the senior partner at Oraro and Company Advocates, and he practices in the dispute resolution practice group with over 33 years of experience. Disputes, constitutional law, electoral disputes, employment and labor law, insolvency and property law. Over the course of his practice, Chacha has also been involved in big ticket asset tracing and recovery matters, such as representing a Kenyan government corporation in negotiating the recovery of depositors USD 200 million from a debtor. He represented the corporation in the initial court processes and is now representing the corporation in the negotiations. Chacha has also been ranked by leading international legal directories such as Chambers and Partners and Legal 500 as a leading lawyer in dispute resolution and employment. In the 2021 Chamber Global Guideline Rankings, Chacha received a plethora of praise from the Kenyan legal community with market observers regarding him as an extremely able advocate and a gentleman in all manner of the world. So I'll invite Mr. Chacha to begin the discussion. Then he'll invite the other guests. Thank you.
Good afternoon, all. Thank you very much. I am glad to be with you this afternoon and to moderate this session. The topic this afternoon is anti-money laundering reporting, obligations, and its impact on the legal profession. For those of us who have been in the profession for a while, will remember that several years ago, there was a motion which was moved by Maina Kiai at one of our ordinary general meetings, where in anticipation of being part of the subject of legislation on anti-money laundering, it was proposed that the Law Society establishes its own code of conduct, which would regulate the conduct of lawyers with respect especially to the receipt and disbursement of clients' funds. Sadly, that motion was defeated without much debate. Fast forward, in the year 2009, and keeping up with international trends, Parliament passed the Proceeds of Crime and Anti-Money Laundering Act, which is an act of Parliament to provide for the offense of money laundering and to introduce measures for combating the offense, to provide for identification, tracing, freezing, seizure, and confiscation of proceeds of crime, and for connected purposes. Under that act, various obligations were set out to various professions, and in terms of reporting institutions, lawyers were left out. However, pending for debate presently in Parliament is the Proceeds of Crime and Anti-Money Laundering Amendment Bill of 2021, which proposes, firstly, to amend Section 2 of the Proceeds of Crime and Anti-Money Laundering Act so as to include as designated non-professional financial business or professions, to include advocates, notaries, and other independent legal professions who are sole practitioners, partners, or employees within the firm. That bill also proposes to amend Section 48 of the Principal Act by again including advocates, notaries, and other independent legal professionals who are sole practitioners. No doubt, this will have an impact on we as lawyers and in our practice of law as we have known it. So today's session comes at a very apt moment when we can discuss what is its impact, so that even as we engage in public participation prior to the debate in Parliament, we do have an informed debate. Today, we will have two gentlemen who are very well versed in this particular area. We have Mr. Saitoti Maika, who is the Director General of the Financial Reporting Center, and Mr. Denis Moroga, who's an advocate and a teacher of law at the Moi University. I will be introducing them with more detail after our chairman, Mr. Eric Theuri, makes his opening remarks. With that, Mr. Theuri, I do invite you to address us. Do we have the chairman on board? Well, if we are, since we seem not to have him on board, I will dive straight into the speakers of today. And as and when the chairman comes in, he will be able to also share with us his thoughts on the proposed amendments. Our first speaker, as I'd mentioned earlier, is Saitoti Maika. Mr. Maika holds a BA in International Relations and Diplomacy. Further, holds a diploma in Security and Strategic Studies, and presently is on an MA program in International Relations, National Security, and Foreign Policy as majors. Mr. Saitoti has over 2 decades experience in public service, mainly acquired in the national security sector. Saitoti was appointed Director General, Financial Reporting Center in July 2017, and prior to his appointment, he served as a Senior Security Advisor to the Cabinet Secretary of the Ministry of Interior. That was as between 2015 and 2017. His previous service includes 15 years in the National Intelligence Services, where he served in various capacities, mainly in the counter-organized crime, firstly as head of the counter-organized crime unit, also as head of counter-narcotics unit. He has also served as the head of counter-terrorism unit, and lastly, he served as an assistant director, counter-organized crime directorate. Prior to joining the National Intelligence Service, he served for 9 years in the Kenya Defense Force, retiring with the rank of captain. Saitoti is a recipient of the Commonwealth Chevening Fellowship and the UN Peacekeeping Medal. In his position as the Director General of the Financial Reporting Center, he is also the Secretary to the National Anti-Money Laundering Advisory Board and the Ministerial Committee on Combating or Financing of Terrorism. Since the year 2004, Mr. Saitoti also has been a member of the National Task Force on Anti-Money Laundering, as well as member of the Task Force of Senior Officials of Eastern and Southern Africa Anti-Money Laundering Group. With that wealth of experience and with the knowledge acquired while serving various capacities, we are extremely pleased to have Mr. Saitoti Maika to take us through the next session of the program. and that is to discuss with us or to share with us the anti-money laundering reporting obligations. Mr. Maika, thank you very much, and I do invite you to address us.
Thank you very much, convener, and good afternoon, everyone. I'm really humbled to share with you our experience, as well as to enlighten the legal fraternity on the AML CFT obligation that are entailed in the amendments that we want to bring to POCAMLA. That's the Process of Crime and Anti-Money Laundering Act. Similarly, humbled to partner with the legal fraternity in combating money laundering and terrorism financing, because by and large, from studies that have been done globally, not just in Kenya, there is always a correlation between money laundering and the legal fraternity. Not necessarily because they are willful partners, but because to a large extent, criminals tend also to abuse the legal framework to perpetrate crime. Mr. Convener, allow me to project a presentation that I'll have wished to present, just to be able to articulate some of the issues that I think are pertinent to this discussion today. And my presentation will basically cover the international framework that governs AML-CFT enforcement. And I'll also share with you the existing legal framework that the amendments intend to extend to the legal fraternity. So allow me to just project that presentation, and then we continue. How do you share the screen, please? Yeah, yes. Just a few minutes as I'm being assisted, technology issues. Yes.
No, that's okay, DG.
Yes. Yeah. I'm able to understand that I have to log in on this machine as I was using the main conference facility. So just bear with us, maybe 2 or 3 minutes will be done.
We'll wait. Thank you.
Recording in progress.
Yes, we can now see your shared screen.
Yes. So basically the scope of my presentation, I'll try to summarize in probably max 20 minutes. I just give a background. And then we'll look at the FATF, the international instruments that, that brings on board. Okay, thank you. The instruments that basically give a foundation of legislation against money laundering and terrorism financing, we look at the FATF recommendations and the lawyer's obligation under these recommendations. FATF is a financial action task force, which is basically the international standard setter. And then we look at the Proceeds of Crime and Anti-Money Laundering Act requirements that we intend, that are already existing within the reporting obligations. And then we look at the money laundering and terrorism financing vulnerabilities and the FATF application to the legal sector. And then we'll also look at the attorney-client privileges and the confidentiality debate, which actually has formed the biggest part of the challenge that we have in terms of how do we onboard the legal fraternity into the reporting regime. There are 3 main conventions that are basically the foundation for my AML-CFT initiatives. There's the Vienna Convention, which is a convention against narcotics and psychotropic substances. There's a Palermo Convention, which is a UN convention against corruption, organized crime. And then Merida Convention, the UN convention against corruption. And of course, the FATF recommendations. Point to note is that for the longest, FATF had remained more or less an organ of the G7 and ultimately the G20. But in 2019 and 2020, the UN Security Council recognized the FATF as not only a global standard setter, but also an instrument or other instrument that can be used to fight money laundering and financial crimes. The Vienna Convention was passed in 1998. Basically, it was a legal mechanism for enforcing previous conventions on narcotic drugs and psychotropic substances. And it was also devoted to fighting organized crime by mandating cooperation, particularly in tracing and seizing drug-related assets. It also provided a legal basis for extradition in drug-related cases among countries having no other extradition treaties. And then the provisions are also subject to party state constitutional principles and the basic concepts of its legal system. And of course, the idea there is that our law remains supreme as much as we recognize these conventions. The Palermo Convention of 2000 was basically the UN Convention against transnational organized crime. It was adopted as a multilateral treaty. It came into force in 2003. And what this convention does, it provides for measures to create domestic criminal offenses, a framework for extradition, MLA, and law enforcement cooperation. Subsequent to the 2000 convention, there are 3 other protocols that are incorporated in this convention. There's a protocol to prevent, suppress, and punish trafficking in persons, especially women and children. Protocol against smuggling of migrants by land, sea, and air, and then this protocol against illicit manufacturing and trafficking in arms. These were just subsequent protocols that were added to this convention. The Merida Convention of 2003 is the only legally binding universal anti-corruption instrument. It came into force in 2005, and the convention approach and mandatory character of many of its provisions make it a unique tool for combating corruption. The convention also covers 5 main areas, namely preventative measures, criminalization and law enforcement, international cooperation, asset recovery, and technical assistance, as well as information exchange. It also provides for implementation review mechanism, which is basically a peer review process that states parties to effectively implement the convention. The convention binds countries to render specific forms of MLA in gathering and transferring evidence for use in court and extradition. These are some of the provisions within this convention. The Financial Action Task Force was founded in 1989 by the G7 to develop policies to combat money laundering, and later in 2005, after September 11, they included terrorism financing. Its main objectives are set out in its standards, which go by the name 40 recommendation, that promote effective implementation of legal, regulatory, and operational measures for combating money laundering, terrorism financing, and proliferation financing, and other threats to the integrity of the international financial system. These recommendations or standards ensure a coordinated global response to prevent organized crime, corruption, and terrorism. And what the FATF does is that it monitors progress in implementing its recommendation through a peer review or process that goes by the name mutual evaluation of its member countries. It also provides for sanctions against non-compliant countries. They do this through a listing process where countries that are either uncooperative or are not abiding by these standards are listed and brought to the attention of the global financial system to be wary of the inherent strategic deficiencies that can pose threats to the global financial system. Basically, to put this into perspective, is that Kenya will be going through this process next year, 24th of January to 4th of February. And basically, the last time we were reviewed was in 2010, that's 11 years ago. And the review is done periodically, 10 years, once every 10 years. In 2010, Kenya had 11 strategic deficiencies. Among them, the issue of the legal fraternity not being part of the AML CFT reporting regime. Out of the 11, the only outstanding strategic deficiency right now, based on the last review, was the issue of the lawyers not being part of the AML CFT legal framework or other reporting regime. And the FATF obligations are that it implements relevant UN Security Council resolutions, that the 2467, 1373, and 1267. These UN resolutions are basically touching on the issue of terrorism. It also criminalizes money laundering and TF and enable authorities to confiscate the proceeds by basically laying out a framework in which the legal regime should adopt in order to be able to criminalize money laundering and terrorism financing. It also put a lot of emphasis on the implementation of customer due diligence, record keeping, suspicious transaction requirement for financial institutions and designated non-financial businesses and professions. Convener and the members, you realize that by and large, POCAMLA dwells a lot on the financial institutions. But again, there is the issue of the designated non-financial businesses and professions that are basically involved in financial transactions. And that's how the accountant's professions and the lawyer profession is being considered as part of the regime. It also recommends establishment of a financial intelligence unit to receive, analyze, and disseminate suspicious transaction reports from reporting institutions. And basically this, in our law, this is the enabling provision that establishes FRC. It also calls for cooperation internationally among countries in investigating and prosecuting money laundering. Why is FATF important for lawyers? The role of the legal professional in supporting the negotiation of businesses and other agreements is vital in any country's economic growth. But you realize that yet as gatekeepers to the financial system, lawyers may be unwittingly exposed to potential money laundering and terrorism financing schemes. And Chair, we are all alive to more or less the issue of the Panama Papers and the Pandora Papers, where basically you see that your profession is very, very important in facilitating financial transactions. But by and large, you can also be exposed to risks and vulnerabilities out of activities of clients who you might not be in a position to ascertain whether they're involved in any criminality. Therefore, lawyers are expected to identify, assess, and understand their money laundering and terrorism financing risks, exposure, and to take reasonable and proportionate measures to effectively mitigate and manage the risks. As such, the FATF obligations are aimed at enabling lawyers to protect the integrity of the financial system as well as their profession by providing law enforcement with relevant information needed to take action against financial crime. Now let's come to POCAMLA, the Process of Crime and Anti-Money Laundering Act of 2009. This is our domestic law. It was enacted in 2009, but it became operational in 2010. And what this law does through the provisions of this act is that it criminalizes money laundering and related offenses, and it also introduces measures for combating crime. In terms of the definition of money laundering, as a predicate offense, this law took an all offense approach. So it's not more or less like other legislations where the offenses are classified. Ours took an all offense approach. Any offense that generates proceeds, then those proceeds becomes a subject of investigation in regard to money laundering. It also provides for administrative and civil penalties for non-compliance. This applies to the reporting institution, or rather all those who are obligated under this law to abide. It also provides for the identification, tracing, freezing, seizure, and classification of the proceeds of crime. And pursuant to the other provisions in this act, it establishes the Financial Reporting Center, which is the country's financial intelligence unit. It also establishes the Asset Recovery Agency and the Anti-Money Laundering Advisory Board, which is basically the national AML CFT policy organ. It also establishes the Criminal Asset Recovery Fund, which is currently, the regulations are out for public participation before we officially establish this fund. What are the requirements under POCAMLA? One of them is that a reporting institution shall as far as possible examine the background and purpose of all transactions carried out by its clients through continuous due diligence. A reporting institution shall also monitor on an ongoing basis all complex, unusual, suspicious, large transactions, whether completed or not, and shall report any suspicious or unusual transactions or activity to the Financial Reporting Center immediately, and in any event within 7 days of the date the transaction or activity that is considered to be suspicious. It also set a limit in which a reporting institution shall file reports on all cash transactions equivalent or exceeding an equivalent of US dollars 10,000. This is basically the 1 million rule that banks enforce. And then a reporting institution shall also take reasonable measures to satisfy itself as to the true identity of its customers, including ultimate beneficial owners. A reporting institution shall establish and maintain records of all transactions for a period of at least 7 years. A reporting institution shall also conduct risk assessment and have policies and procedures to address any money laundering or terrorism financing risks. Let's look at the money laundering and terrorism financing vulnerabilities and the FATF application to the legal sector. And of course, I've already mentioned that the legal professionals provide diverse services to their clients. Some are litigation-based, while others are non-litigation-based. In 2010, the Eastern and Southern Africa Anti-Money Laundering Group, of which Kenya is a member, conducted its first round of mutual evaluation, which identified the non-designation of lawyers as a significant deficiency that exposes the country to high risk for money laundering and terrorism financing. And of course, the worst case scenario is that if a country, not just Kenya, if a country is not able to demonstrate that it's dealing with these vulnerabilities and deficiencies, then it can lead to basically the blacklisting by FATF. If you look at our statistics from 2012 to date, So far, we've had a reporting on 333 lawyers who have been reported for potential money laundering and terrorism financing activities, while 678 reports indicated that lawyers assisted their clients in suspicious transactions. And so basically from all these reportings, basically what I'm trying to say is that for sure, the vulnerabilities are there. And we know that some of them are just out of activities of your own clients, not necessarily the activities of the lawyers. It's just activities of the clients. But looking at the kind of services that you offer, then these clients end up actually exposing lawyers for reporting to the financial reporting center. But this does not necessarily mean that all these have led to live cases, which we forward to law enforcement. Basically, what I'm saying is that there are activities that border on a lot of issues that create vulnerabilities for the legal profession. Application of the FATF obligations to lawyers. The FATF obligation only apply to 5 categories of specified activities. And these are legal advocacy before courts and tribunals and representing clients in dispute mediation. These are the ones that don't fall under the requirements of FATF in terms of reporting. Advice on divorce and inheritance and custody proceedings, that's basically family law matters. Legitimizing signatures by confirming the identity of the signatories, e.g. commissioners for oaths, and tax advisory matters. These are the legal services that do not fall under the FATF recommendations, basically the standard which talks about how the legal profession should deal with the money laundering and terrorism financing. So what are the specified services that fall under the FATF obligations? One is that the issue of clients' funds in relation to managing the money, securities, and other assets of clients, opening or managing bank, savings, or security accounts. 2, advising on the purchase and sale of real property or real estate for that matter. Organization of contributions for the creation, operation, or management of companies. And lastly, formation and management of companies and trusts. The issue of the client's funds. Client accounts are accounts held by legal professionals with a financial institution. And of course, basically, these are money, securities, and other assets of clients, which are to be used in accordance with the client's instructions. So the FATF obligation requires legal professionals to conduct ongoing due diligence to ascertain that clients' transactions are consistent with the lawyer's knowledge of the client, their business and risk profile, including where necessary, the source of funds. And the aim of this obligation is that no funds may pass through a client account without being attached to an underlying legal purpose. Mr. Convener and members, basically looking at the whole issue of the reporting that POCAMLA intends to extend to the legal profession, this is basically what we are saying, that the aim is to ensure that any monies that are handled by lawyers or by the legal profession should have an underlying legal purpose, and of course, the source being legitimate. The issue of advising on the purchase and sale of real estate. Real estate accounts for a high proportion of confiscated criminal assets, demonstrating that this is as a clear area of vulnerability. In the case of NIS 1, we saw this happening, and I think it's unfortunate that we ended up having a law firm and a lawyer being charged in court for transacting in the NIS 1 case. Legal professionals are involved in the transfer of property through negotiations, contracting, and outright purchase on behalf of their clients. This exposes them to criminals seeking to exploit their legal services to obscure the ownership of real estate. So basically, the FATF recognizes that lawyers will typically be aware of the financial details in real estate purchase, hence in a better position to inquire about the client's source of funds. On the issue of formation and management of companies and trusts, criminals often exploit available opportunity to retain control over criminally derived assets, while frustrating the ability of law enforcement to trace the origin and ownership of these assets. Common typologies, these are researchers, involve the use of all shell companies which do not have any ongoing business activity or activities or assets to serve as a transaction vehicle or to conceal beneficial ownership. In some cases, criminals nominate legal professionals to the management of companies and trusts in order to provide greater respectability and legitimacy to their activities. Criminals may also seek to misuse shell companies sitting on the shelf to create the impression that the company is reputable and has been in existence for many years. In all these typologies, lawyers provide legal advice for the creation and management of such companies or trusts, or otherwise act for companies or trusts. Thus, funds relating to criminal activities may go through the lawyer's client account, thereby exposing them to being a party to the client's criminal conduct, which may not be protected by the legal professional privilege. On the issue of the advocate-client privilege, privilege of professional secrecy is a protection to the client and a duty to the legal professional. It's based on the rationale that the rule of law is protected where clients are encouraged to communicate freely with their legal advisors without fear of disclosure or retribution. However, there must be balance. There must be a balance for the right of access to justice and the public interest in investigating and prosecuting criminal activities such as money laundering. Hence, the legal professional privilege does not protect a lawyer from knowingly facilitating a client's illegal conduct merely because he or she is a legal professional. By virtue of existing professional code of conduct, lawyers are already obliged to profile their clients for conflict of interest. So basically, what I'm saying is that AML CFT obligations are not exceptional obligations. It is important to distinguish between legal advice, which generally is protected, and underlying facts, which in many cases are not protected by privilege. The matter that would fall under legal professional privilege or professional secrecy are clearly outlined in the existing provisions of Section 18 of POCAMLA and the Evidence Act, and we'll get to this later towards the end of the presentation. So the AML CFT obligations only reinforces a position already existing under Kenyan laws. If you look at Section 18.1 of POCAMLA, it expressly protects the client-advocate privilege relationships with regard to communication of privileged information between the advocate and the client. And allow me to quote, it says, 18.2 qualifies this exemption to only apply in connection with the giving of advice to the client in the course and for the purpose of professional employment of the advocate or in connection for the purpose of legal proceedings on behalf of the client. Therefore, you realize that the client confidentiality is basically protected in court proceeding under Section 18.4, in which provides that nothing shall require an advocate to comply with a court order to the extent that such compliance will be in breach of the attorney-client privilege, which is already articulated in 18.1 and 2. But you also realize that the legal privilege is not absolute. If my reading of Section 143.1 of the Evidence Act exempts any communication made in furtherance of any legal purpose or any fact observed by an advocate in the course of his employment showing that any crime or fraud has been committed. Therefore, the proposed amendments to the Act are only meant to align to the provisions of Section 134.1b of the Evidence Act already existing under our statutes. So basically, Chair, what I'm saying is that there is already that obligation for the lawyers to identify any criminality when dealing with their clients, where basically it touches, where it doesn't touch on the issue of the privilege for litigation. So looking at the FATF obligations and legal privileges, you realize that the FATF obligations apply mainly to factual information and conveyancing matters, which do not form legal advice, but based on commercial relationship between the parties. That's basically the advocate and the client. So the legal privilege protection in the following circumstances are exempted from the FATF requirements. This is when an advocate acts in the course of ascertaining the legal position of their clients or in performing tasks of defending or representing clients in judicial, administrative, arbitration, and mediation proceedings. The above two circumstances are not similar to conveyancing transactions, which are purely commercial and which FATF has specified due to their transactional nature. How will lawyers report and be regulated under the proposed amendments? Chair, this is very important because the number of interactions we've had with the fraternity, so far we've done 5 regional seminars. This issue has always come up, that how do you bring in the issue of the reporting without infringing on the existing privileges? The LSK as it stands now does not have the powers to regulate and supervise the members for MLCFT purposes. I think this is not extended to LSK as currently enacted. For the LSK to be designated as a supervisory body under POCAMLA, lawyers will first need to be designated as reporting institutions under the definition of the designated non-financial businesses and professions. Subject to the FRC powers under Section 36A of POCAMLA, LSK will then be empowered as a supervisory body to regulate and supervise their members for MLCFT purposes, but still remains a self-regulatory body. Reporting of suspicious transactions will, however, remain to the FRC as set out in Section 44 POCAMLA and as required by the FATF standards on centralized reporting. Basically, what the FATF standard says that there shall be a central authority for reporting of STR, so that cannot be shared with any other body. Has this worked elsewhere? Basically, I've also tried to list down a few countries that have put in place these requirements where the legal profession is already designated as reporting entities. There's Botswana, there's Uganda, there's South Africa, Ghana, Eswatini, Lesotho, Tanzania, Zambia, Australia, which is a Commonwealth, Mozambique, the United Kingdom, Mauritius, France, Seychelles, Zimbabwe, Nigeria, Rwanda, and lastly, you won't believe South Sudan and Somalia. And many of these countries are under the FATF regime. Chair, Mr. Convener, let's look at the whole issue of us not having these amendments passed. Basically, what I'm saying is that Kenya is due to undergo the next assessment in January. And the main aim of this assessment is that it will assess compliance with the FATF standards. And basically, it will have to highlight the risks. It sets out clear direction for policymakers. And then it will also enable peer pressure on member countries. And then the peer review achieved by expert assessors supported by professional secretariat. Basically, this is the one that drives this process. And then the ultimate outcome of all this will be placed before the regional grouping plenary for adoption. And this is the way the FATF methodology works. One, we need to identify the risk and context, and then we have to look at the technical compliance, which is basically the issue of the whole framework, the legal framework, the regulatory framework, and the policy framework that governs MLCFT issues. And then again, there is the issue of marrying the technical compliance with effectiveness. How effective are these laws? And basically, they look at the effectiveness assessment of all those who are involved in this framework. And then the report will draw up integrated conclusions and recommendations. And these recommendations are the basis in which now determination will be made on how to deal with a country that has serious strategic deficiencies. The issues to be considered during this evaluation is, I've already mentioned the issue of risk and context. The evaluation will look at the money laundering and terrorism financing risks in the country. It will also look at the country's circumstances and materiality. Of course, the structural elements, which laws are in place, which framework is in place, who plays what role, and other contextual factors. The structural elements will look at the political stability. It will also look at the high-level commitment to address MLCFT issues. To also look at stable institutions with accountability, integrity, and transparency. To also look at the rule of law, where, I mean, if we are not abiding by the rule of law, then that becomes also an issue in the assessment. And then it will also look at the independence and the efficiency and the capability of the judicial system. And then when they're looking at the country's circumstances, it will basically look at the broad makeup of the economy, to look at the size and structure of the financial and designated non-financial businesses and profession sector, to look at the specific area of interest, the cash economy, the offshore sector, cross-border flows, and informal economies. And basically, Chair, when you're looking at this factor, you realize that we're in the process of establishing the Nairobi International Finance Center. And the whole issue of the offshore sector will also come into play, whether we really have the ability to establish that center, having the necessary structures, the legal framework that deals with the MLCFT issues that might be involved in all those transactions that go through that center. and the basis for judging the relevance and importance of specific issues. And then, Chair, again, there is the issue of the ME recommendations, whereby the recommendations on how country can improve its AML CFT system. To look at the integrated effectiveness and technical compliance, it will also look at how we have prioritized based on the country risk and weaknesses, what needs to be done, and then it will also set clear goals with discretion about how to meet all these goals. And basically that brings me to the end of my presentation. And Chair, I know now we need to look at a debate in which the legal profession, I know they want to engage FRC on how do we come on board and what needs to be done in the event that the amendments are passed by Parliament. Thank you very much.
Thank you very much, Mr. Saitoti Maika. I must say you have given us so much material to provoke a robust discussion. And whereas I'd have asked the discussion to commence straight away, I will ask you if you could just remain on board. My chair has come, Mr. Eric Theory, and he's heard you. Probably I would propose that Mr. Theory talks to us first, and then we will ask Denis Moroga to also input, after which we will open the session for discussion. But thank you very much for the very, very well researched document and very clear in its terms. Thank you. So may I ask our chair, Mr. Eric Theory, to talk to us? I think, Mr. Saitoti, you can remove your shared screen.
That's what I'm trying to do.
Okay, thank you. Thanks.
Mr. Odera, I think the chair, we keep losing the chair, so we can continue. Then once he joins, we'll communicate.
Thank you very much. Thank you. So, and thank you all for participating. I see on screen we have about 154 people. And I must say that's a really, really impressive turnout. Our next speaker, who will take over from what Mr. Maika has said, and closely related to what Mr. Maika has said, is Mr. Denis Moroga. Denis Moroga wears two hats. Firstly, is the managing partner in the firm of Moroga, Wangui and Associates Advocates, and also a lecturer at his alma mater, Moi University School of Law. Mr. Moroga holds both a bachelor's degree in law and an LLM specializing in transnational criminal justice from the University of Western Cape in the Republic of South Africa, in collaboration with Humboldt University of Berlin. He's also a member of the Association of Certified Anti-Money Laundering Specialists. With his wealth of experience, we do welcome Denis to speak to us, after which we'll go to the next session of a question and answer. Thank you. Denis?
Thank you. Thank you, Chair, for the introduction, and also the Director General for his comprehensive presentation. He has actually presented part of the history that I would also have repeated. So allow me to share my screen. I think let me try sharing it. Perhaps confirm that my screen can be seen by the audience.
Yes, we can see. Thank you.
Okay, my focus today would be on the impact of the ML anti-money laundering stroke countering the financing of terrorist reporting obligations in the legal profession. And we go to the outline of my presentation. My presentation mainly would encompass a background to the ML regulation in the legal profession, the scope of the ML regulations, the scope of ML that is ML for money laundering offenses, then the best approach in regulation, the proposed obligations and scope, the likely impact in the legal profession, and finally we will look at the role of LSK before I share my recommendations on the best way forward. The bulk of the history has already been tackled. Perhaps maybe to highlight a few with regard to lawyers, it's important to note that we came on board as reporting entities in 2003. The AML framework was initially from the 1980s. It was focused on drug trafficking. We come to 2000 and that's 1980s. Towards the end, it was focused on drug trafficking and related crimes. Subsequently, in the 1990s, that is when kleptocratic corruption was at the high, and it was deemed fit to include also money laundering offense, corruption-related crimes as money laundering offenses. So when we come to 2003, FATF amends its laws to include lawyers as non-designated businesses and professions because of their facilitative role. Then they widen the scope to include, for example, politically exposed persons. That was in 2003. 2009, Kenya moves to adopt the POCAMLA after a number of unsuccessful attempts. It's important to note that when it came in 2009, then it was proposed by His Excellency President Uhuru Kenyatta. Then he was the Minister for Finance. He underscored key aspects that are important to check the Hansard record. It was meant to combat proceeds of piracy that and partly other transnational crimes that had caused inflation in the real estate sector. And also in part, it was meant also to fight corruption. Then subsequently, after passing the legislation, it took around 3 years for the FRC to be established. Then operationalizing took around 5 years, I believe. Even now, still there are other places where the FRC is still operationalizing, especially it seeks to join the Egmont Group, among other infrastructure, having the capacity to analyze and receive all transactions in the country. So those are things that are still establishing. Then now we come to 2019, that is when we have the proposed bill for lawyers. And there was also an unsuccessful attempt to have an LSK draft. In the last SGM, the last SGM that was in 2020, it was shelved, and that has been pending to date. Important to note is that in 2019, the finance bill sought to include reporting obligations to both contentious and non-contentious matters. However, now the proposed regulation, that is the proposed amendment, seeks only to include advocates as reporting entities for contentious matters. So that's the small difference in terms of the regulation history. Its last came a few days ago for the second reading. Important to note also, as we just lay a framework for subsequent discussion, is the scope of Kenya's money laundering offense. The scope is wide. It adopts best practices nationally, where it encompasses, it adopts an all crime approach, such that should one facilitate proceeds of crime from whichever crime, be it as basic as theft, that does not need to have a substantial amount, that you can be held liable for money laundering offenses. The other offenses relating to money laundering offenses under the Act include tipping off, failure to keep records, failure to allow inspection of documents, among others. And also, of course, failure to timely report. If you don't report on time, then you can be held liable for money laundering offenses. The High Court in Republic versus Director General of Director of Public Prosecution, expert Patrick Ogola Onyango held that money laundering is a standalone offense. This means you do not need a predicate offense, for example, corruption, to be proved for you to be prosecuted for money laundering. Failure to undertake any of the procedures in the Money Laundering Act, then you can be held culpable for money laundering as a lawyer. The sanctions are punitive. It includes jail terms, fines, civil penalties, and suspensions. The recent cases by banks, that is the NYS 1 and 2, if you are keen on the papers, you must have seen the hefty sanctions that were meted to banks for failure to conduct money loan, for failure to report suspicious transactions. And note that since banks were already penalized then, the perpetrators, these were the primary perpetrators, are yet to be brought to book. So then as an intermediary, your risks as a person with reporting obligations tend to be high, because then on your side, the regulatory institutions and law enforcement agencies can easily come after you, whereas it's quite difficult to prosecute the primary perpetrators of the offenses. Key players include the Anti-Money Laundering Board, the FRC, as mentioned, law enforcement agencies, and bodies such as LSK, which is proposed. Should the bill pass, then it will be, LSK will be a supervisory body. Remember, when you hear a supervisory body, this is akin to the role played by the central bank to banks. The best approach to regulation. Now, this is a key aspect that most developing countries have shied away, and Kenya is a party, or is among those that have shied away from going with the best approach. In 2003, between 1989 and 2003, money laundering was mainly based on, it was a tick box approach, in the sense that if you go to a bank and a bank notes that your transaction was above the reporting threshold, then it will report the transaction without looking at the quality of the reports or suspicious reports that they are seeking to include. That has a number of challenges. And the obvious challenges would be that you will get very many reports at the FRC or at reporting entities, which do not have any value in terms of intelligence. Remember, reporting obligations helps mainly the government to collect intelligence. Now, in 2003, the FATF has realized that the money laundering obligations are not working. Now it pushes for what we call a risk-based approach to money laundering. The risk-based approach was further foregrounded in 2012, where where recommendation 1 and 2 of the FATF imposes a mandatory obligation that countries should do a national risk analysis. With the national risk analysis, they will be able to identify key risk areas. Where there is a higher risk, then it's from that point that we should come up with money laundering obligations, which should be proportionate. It's important to underscore proportionate because most developing countries, including Kenya, do not have capacity to conduct a wide scale enforcement. So when a country does national risk analysis, then with the reports, and a country does a national risk analysis, identifies key risks, key anti-money laundering typologies, then that forms a basis for intervention. To date, Kenya has not publicized its national anti-money laundering risk analysis. At least it was great that the Director General mentioned a few cases of the statistics on lawyers. I didn't know from that angle. And those are some of the concerns, because when we do not have data-driven enforcement or data-driven legislation, we tend to borrow a lot from the West, from Western countries, without looking at the peculiarities in our country. Then with our proper risk-based analysis, for example, today, we can tell among these cases that the Director General has indicated that they have already been reported, which ones were on contentious transactions and which ones were on the non-contentious transactions, so that when we intervene to regulate non-contentious transactions, the intervention is merited, as opposed to today when we progress without showing that, yes, in Kenya, the risk is high on contentious, whereas the risk is low on non-contentious. And of course, when you do a proper national risk analysis, it enhances effectiveness of the ML measures at the sectorial levels. So as lawyers, we will have a reference point from the national framework. Then maybe at the LSK also, you look at the sectorial risks, borrowing from the national framework. Then now at an individual firm level, you can have what you consider to be your perfect anti-money laundering risk-based measures to ensure that your clients are properly screened and to avoid cases of maybe facilitating money laundering. Without that national risk-based approach that is publicized, then there is a problem that at the sectorial level, it becomes very expensive to intervene and regulate money laundering. And of course, also even in the reviews, that has been reported as one of the weaknesses of the Kenyan measures. And I hope that, I know it's on course, I hope that can be completed and we can have clear data on regulation, which can then inform our interventions. On the scope of the obligation, the amendment has a wider scope of obligations. The DG has, the Director General that is, has already explained some of these obligations. I will just underscore what is important. The first bit, you will note that the amendment seeks to delete reporting obligations under Section 48. That means the obligations are not limited to reporting. So once the obligations are not limited to reporting, lawyers have to do all money laundering obligations. These include conducting the enforcing the know your customer principles, enforcing also the conducting customer due diligence, keeping records for 7 years, and as well as keeping records for 7 years, and as well as allowing inspection of records in your chambers. Now, the scopes include buying and selling real estate, managing client securities, of course, management of bank savings and our securities, organization of or contribution of organizations or contribution for the creation of operation of management companies, and also the creation operation of buying land, buying and selling business entities, and also legal arrangements. There's also a provision on trusts. So when you are establishing trusts, you will have a money laundering obligation. We move to what are the key now? What should lawyers do when they are handling the above listed transaction? One will entail conducting customer due diligence, keeping records for at least 7 years. And remember, when you lose the records, that is a money laundering offense. Reporting suspicious client activities under Section 44, all these are obligations, as well as allow inspection of books of account and documents, which then especially inspection of documents that can easily lead to a violation of advocate-client confidentiality. Now, it will be important to note the obligations now, because my next slide is on the impact of the reporting obligations. The key movers global framework on ML, on anti-money laundering, would say that it's aimed at reduction of criminal activities. I agree with that. It's true that there are cases where lawyers can be involved in facilitating crime. And this is the core drive towards regulation of money laundering. However, what we need to ask ourselves is, when we borrow the legislation and paste in Kenya, are the functions regulated exclusively meant for advocates? For example, buying and selling land. There are many we do not, lawyers do not play a central point in buying and selling land. In villages, or even depending on the level of competency of some clients, lawyers can easily be reduced to reviewing an agreement. Once you review the agreement, a client can proceed and register without a lawyer. There are many transactions that happen without lawyers being involved. And we do not now see how, if the law regulates lawyers, how does the law propose to cover those clients who will decide to commit money laundering, or even those that will decide not to use lawyers in conveyancing transactions? Another aspect, formation of companies. Today, anybody with an e-citizen account can establish a company. What would be the incentive of clients going to lawyers, knowing that lawyers would certainly have to report them to the FRC? Not that our clients are generally suspects of criminal offenses, but we are a society where people keep their things private, including sometimes even achievements. People tend to keep them private. Certainly when you are purchasing an asset and maybe you are told that now the government has to be told that you are purchasing this property at this amount, certainly then that of course would enhance more underhand practices, where maybe an advocate is only contacted to review a document, you don't stamp it, and you let the clients proceed and register. If it's a company, then an advocate is only told, check the documents whether they are okay, I will register on my own. So of course, that then has an impact in terms of professional conduct, effectiveness in terms of business, and the reach as well. So therefore, if the law could, if that could be a reality that could be factored in at the regulation stage, I think there could be a more informed approach. Either make the law, make these functions that we are reporting on compulsory, that an advocate must be involved. So then there is no option of diverting. And another point to underscore, today we have a clear, we would mention that there is a divide between contentious and non-contentious matters. How true is that? Today, when you originate a transaction like a land sale agreement, you have an obligation to report. Tomorrow, when the buyer defaults, you start litigating the case, the obligation to default does not exist. A client who knows, of course, they will suspect that you are the one who maybe reported them. The moment now a criminal case is initiated, what are the chances that those clients are likely to retain you? Certainly, they are not likely to retain you. They will move to another lawyer. So the contentious and non-contentious divide is something that need to be clearly thought out. It's yes, easy to say we are working in non-contentious, but sometimes the lines are blurry. It's never a clear-cut distinction. There is the risk that these laws will erode advocate-client confidentiality and the right to privacy. Certainly, in fact, even the proposed amendments now seek to erode further the right to privacy, in the sense that communications can be tapped, can be recorded or intercepted without court orders, which then, when you look at that on the right of advocate-client confidentiality, then there are legitimate concerns that we have to ensure that it's only through reporting obligations that they can be solved. Especially the fact that Section 134 of the Evidence Act would not allow advocates to be involved in criminal prosecution, crimes. We are, of course, a profession that rides on upholding the rule of law. And if today there is lawlessness in the country, or there is a surge in criminal activities, advocates are the first people who would not be able to practice their professions. Therefore, we are enjoined already to practice our profession in an environment that we do not further crimes. Yes, there are those that are perpetrating crimes. You may not say nobody is involved, but the scales will be important, as well as the specific, maybe generally, we should know that, yes, we failed to enforce these particular orders because of A, B, C, D reasons. As opposed to where now we'll say, yes, this is a general risk for lawyers. and we have to ensure that there is enforcement. Another aspect, of course, is mistrust and suspicion. Clients, because generally, even distinguishing between contentious and uncontentious is not an easy task. How will clients know that when they're coming to your office, this particular transaction, you won't be able to report them, that this is an uncontentious, whereas this is a contentious matter? Those are issues that they're going to affect our practice, because it's true that where clients know that when they are confiding to an advocate, there is a risk that they will be reported, then certainly it has greater concerns in terms of compliance. So in terms of ensuring there is a relationship between an advocate and a client. Then there are continued impact. Another impact that is worth noting is the increased compliance costs. Lawyers lawyers practice in diverse arrangements. There are those that practice under small firms, some practice under big firms. However, in both, for once money laundering obligations are imposed under the Act, we will have to get human resource capacity, either if you are an individual trained for money laundering offenses. Of course, there is also hiring ML staff that would be mainly for big firms. There are attendant costs, for example, record keeping. Remember, if you keep a record in this case, it's 7 years. And should maybe the FRC or law enforcement agencies come after that one document, after 5 years and you do not have it, you have committed an ML offenses. Another risk that is likely to be experienced is sanctions. There are fines, deferred prosecution arrangements, plea bargaining agreements. These are likely the common ways of regulators enforcing. We have both administrative sanctions as well as the DPP can as well institute criminal offenses. So if you are prosecuted today, let's say for money laundering offenses, the FRC, or in that case, if the LSK would have capacity, can enforce sanctions. Then subsequently, the DPP would also have to institute criminal proceedings, because most of the obligations under the POCAMLA, when they are not adhered to, they lead to a money laundering offense. There's also suspension and revocation of licenses under Section 24C of the POCAMLA. Those are all risks that one has to be alive to, especially when there is a suspension of record. Most advocates, most of us are mainly relying on our PC to practice law. And once the PC is suspended, then that means we do not have to practice law. Reputational risk is a greater concern. Today, the DPP would parade a suspect. Remember, it's not that you've played a primary role in money laundering offense. You will only have played, maybe you failed to keep records, but when the DPP maybe arrests you for failing to keep records, you'll be paraded with the placards for committing a money laundering offense. Unlike companies that maybe have a corporate identity, advocates have their personal identity. That is your tool of trade. Your identity is a tool of trade. When you are paraded by the DCI or law enforcement agencies, and it's reported in the media that maybe a city lawyer nabbed for money laundering, whether it's failing to report, whether it's an offense as maybe failing to report, or not having clear reporting structures and delaying to report. Remember, reporting should be done within 7 days. If you delay reporting, there is a risk that then there's a risk that you can be arrested for money laundering. There is personal security. Personal security is important. The other time we had a conference for global anti-money laundering, global South, colloquia on illicit financial flows. a lawyer from Kingston, Jamaica, indicated that they are also contesting these regulations because if you report in Jamaica, how will you go home that day if you have reported the top criminal entities to the FRC? How sure are you that your personal security would be guaranteed? There are loopholes that can be seen. We've had cases where advocates have disappeared from court, not to be traced. We have had cases where witnesses have disappeared, not to be traced. How sure are we that when we report criminals, which ordinarily is a tax-funded mandate by the police, is a tax-funded mandate by the police, how sure are we that our personal security would be guaranteed? Those are concerns that are legitimate. And as we talk towards having reporting obligations, then we have to be assured. There is also abuse of ML laws. There are, to contextualize the abuse of ML laws, we can draw back to the East African community. In 2020, there was Nicholas Opio, an advocate from Uganda. He was accused of money laundering. Of course, this was representing Bobby Wine. Subsequently, 2017, the allegations, the offenses were withdrawn. Tanzania, 2019, there was Tito Magoti. Of course, this was 1 year, he served a 1 year jail term. Remember, not a jail term per se, but in Tanzania, money laundering offenses are not bailable offenses. So if you commit money laundering, you can actually be in custody as you do your trial. So he stayed almost 1 year. Then there was, of course, a plea bargain and he was released. Amnesty International notes that there are allegations of abuse. So that is the source of why I indicate that there are allegations. So in Kenya, how sure are we that the law enforcement agencies would not use these anti-money laundering laws, not for the designed purpose, but instead to affect, to intervene with legal practice? These are legitimate concerns that if in the event that the regulations are being implemented, then we have to make sure that we have proper approach. There are countries like South Africa that took a broader approach. Of course, they included both reporting and unreporting, both contentious and non-contentious. However, it hasn't been rosy for them. Many lawyers in South Africa, if you had a chat with them, would complain about how sometimes enforcement infringed on the right to privacy, among other legitimate concerns. Now, the role of the LSK. The money laundering obligations proposes to make the LSK a supervisory body. There are capacity concerns. I do not know whether maybe the FRC has engaged with the LSK to ensure that there is a capacity to address that. There are countries, for example, France and the UK, where their respective bodies have been spearheading the move to regulate. They are spearheading the move to regulate within the profession. And of course, that is something that can be deliberated as to whether the LSK would have that capacity. That then is on the members to decide. There is now the last part is also the, also it's important to note that whereas advocates are proposed to be included as reporting entities, we do not have an equal mandate to sit at the Anti-Money Laundering Advisory Board, which our counterparts, for example, accountants already sit in that board. So that would be an issue that should be addressed. We ensure that in the event then we have to be reporting entities, let us have a representative and at the Anti-Money Laundering Advisory Board. Otherwise, then why would other players, for example, accountants, have a seat at the board? Then there are a few recommendations that I'll make. One is conduct a national risk analysis. Let us have data-driven intervention, because also the lack of data-driven intervention has seen other players like car bazaars the other day were excluded. We do not know why they were excluded. However, car bazaars, some stakeholders I was engaging with prior to these were indicating that they actually needed the regulations and they were pushing for the regulations to be there. Why then would we say car bazaars are not regulated, those that are maybe dealing in selling and buying cars, but lawyers who are just doing a sale transaction agreement are the ones to report. There is also adopting a risk-based approach at the national framework. That would be key to make our laws work. With a risk-based approach, we can even explain to the assessors, when the assessors come, let us show them that lawyers in Kenya do ABCD obligations. However, these obligations are not restricted to lawyers, such that even if we were to regulate lawyers, then they can't solve the existing problem. Otherwise, of course, the international community will say Kenya regulates lawyers, which will be a good report for us. But in the country, will the legislation be effective? There is a need to engage the FRC in the LSK, of course. There is need for an engagement between the LSK and the FRC. Other alternatives that I could propose is, what if lawyers avoided cash transactions? Would that help? Because if we avoid cash transactions, banks conduct KYC and customer due diligence, then even at the moment, any transaction you want to transact for an advocate, for a client in a bank, you have to provide justification. Perhaps avoiding cash transactions could see lawyers adequately address money laundering risks. There is also, in terms of registering land, as well as companies, can we have enforcement at the registry? Let us make it the duty of the land registrars to ensure they ascertain the source of funds at the time when a transaction is being processed. That could help in the sense that we will shift the burden from lawyers who are individual entities and they are not funded by the state, to company registries, land registries, who can actually ensure that no conveyancing is registered without someone proving the another aspect also is, for example, creating a seat for the LSK at the Anti-Money Laundering Advisory Board, and maybe to underscore the last is reporting obligations should cover services that are exclusively for lawyers. Where reporting obligations do not cover services that are exclusively for lawyers, we have obvious risks, underhand practice that we may not address. There is, of course, consistently enforcing, of course, the ML measures. In Kenya and a few countries that the Director General mentioned, it's true that lawyers have reporting obligations. However, there are countries like the USA where they have an effective enforcement model. As such, lawyers do not have reporting obligations in the USA, Canada, among other jurisdictions. Whereas it's true that there are countries with reporting obligations, for example, South Sudan, Somalia, they do not have the infrastructure to enforce. These are countries that moved forward to comply without having any basic infrastructure. If I recall, unless things have changed, South Sudan has not established a financial reporting center. It's in the statute, but it's not physically established. I do not know the case of Somalia. However, it's important to note that most countries in Africa, a country that actually enforces is South Africa. South Africa has adopted and enforces. Tanzania, Uganda, I'm not sure about enforcement, the extent of enforcement, but of course, there are cases of targeting lawyers for other purposes. And finally, there's need to create awareness among lawyers so that then going forward, we know what our obligations are. There's need for more interaction between lawyers and the FRC so that we do not see FRC as maybe a police institution. And for that, it's great that the Director General has been part of this conference. So I believe that this is maybe a continuation of continued engagement between lawyers and FRC with a view to eradicate crimes. Again, maybe I'll reiterate that in Kenya today, at the heart of the legal practice is compliance with the law and upholding the law. If we do not uphold the law, if we lawyers contribute to a state of anarchy, then we are the ones who suffer the first blow. And that is not a scenario that as colleagues we should encourage. And therefore, even as we continue engaging, it's good to try and those that are culpable then to try and have measures to avoid such crimes. Thank you.
Thank you very much, Dennis. That was an extremely well thought out presentation, relevant to we in practice, and also thought-provoking. And together with what the DG has presented, I do believe there are questions being piled up for the two of you to answer. But before we get there, what I will ask is that our chairman has joined us, and probably Dennis, you can stop sharing so that we can hear from our chairman, after which I will ask those with questions to post it on the chat, and it will be presented to the two panelists for their consideration and answers. So it gives me immense pleasure to introduce to you our chair, Mr. Eric Theuri. And Mr. Theuri, the floor is yours, or rather the screen is yours. Kindly address us.
Chacha, you can hear me?
Yes, sir, we can hear you and see
All
you.
right. Thank you. Thank you so much. I'm sorry I'm joining in a bit late. I got this midway and I didn't want to interrupt it. I traveled out of town for some business, and I had to try and make time for this. But I just want to, first of all, pass my appreciation to both Denis and Saitoti for the presentations. Very, very elaborate. Presentations. I cannot thank you enough.
Sorry, Chair, you are frozen. Chair. Chair, I think you are muted and frozen.
Oh, sorry, I can hear you.
Okay, go ahead. Now we can hear you.
Sorry. Perils of being of network. Sometimes it can let you down when you need it most. So I was just saying, passing really appreciation. And I'm hoping that the lawyers who are on the call and the webinar have found the sessions as useful as I did. And as I think I want to echo what Denis has said, that as lawyers, we have a responsibility to uphold the law, but we also have a responsibility also to interrogate the provisions of the law vis-a-vis our obligations to the profession. And so I think that there is a timely discussion in light of the proposals for amendment that have been put forth in Parliament. And I'm hoping that then this discussion helps us to illuminate those proposals and make them useful to the profession, of course, noting the challenges that are imminent on the profession as a result to the international push towards embracing tougher regulations against money laundering. So I take cognizance of the fact that my network may not be very good, so I would not want to say much more, because I also know that the presenters may have to respond to one or two questions. But I think from our end is to say that as a branch and as a leadership, we remain willing, ready, and able to engage with the FRC and our members who are experts in this area to ensure that whatever legislation or regulation that comes out is good for the profession. So Senior Chacha, I thank you and enjoy your afternoon, and asanteni sana to the presenters.
Thank you, Chair. We are most grateful for your presence and those very kind words, and the assurance of our position regarding this process as we engage in a debate concerning this proposed amendments, which I am told is at a second reading. So just looking at the chart, Wilfred Nderito, Senior Counsel, has asked if there's a link available for listening to the webinar later. Yes, Mr. Nderito did send me a text telling me he's running a little late, but he's interested in hearing or listening to this presentation. And I do believe the session is being recorded. We were all warned at the beginning that it's being recorded. So Mr. Wilfred Nderito, Senior Counsel, I believe the Nairobi chapter will be able to share those presentations. Caroline Kasoa asks, why is the government avoiding the obvious routes for money laundering? And then he says, she says examples are just one moment. She lists out examples as being, why not Kenya Revenue Authority, Customs, Huduma Service, KRA PIN, land registrars, engineers, SPA registrars, registration of companies and business names, etc. Why can those also be reporting agents rather than burdening private advocates? Ms. Kasoa also asked, what is the role of government advocates, state councils, land officers, registrars of companies, business name, KRA, Huduma, officers, M-Pesa or M-Pesa transfer agents, land planners, surveyors, and environmental assessors? Probably this is a question which would best be answered by Mr. Saitoti Maika. While still at that, so that you take both questions together, Nicholas Njoki is asking, CBK is in the process of amending the reporting threshold of US dollars 10,000. Will this affect the country rating in the oncoming January-February 2022 FATF review, since FATF recommends reporting for any cash equal or in excess of 10,000 USD? May I ask Saitoti to probably share his thoughts on this?
Thank you, convener. Let me take the last question first. The issue of the review of the 10,000 US dollars equivalent. Yes, that is likely to affect the rating, but from my presentation, when I did cover the issue of the mutual evaluation, there are parameters in which this assessment is done. And I did mention the issue of risk and context. So as a country, we'll have to demonstrate why anything beyond what is clearly indicated in the FATF standards, which is US dollars 10,000 equivalent, is not applicable in our case. And I have been a very strong proponent of us reviewing that 10,000 threshold, because whereas in Europe, poking around with $10,000 in the US, or maybe 8,000 pounds or 8,000 euros in Europe, that might look abnormal. Just take the context of us. In my own village, I mean, we deal with cattle. $1 million shillings is equivalent to 12 or 13 cows for that matter. I mean, that's not really something that will drive people crazy that you have such a huge amount of money. If you go to Gikomba, the dealers of Mbao and Gikomba who are transacting cash with traders from Congo and Malawi 1 million shillings is very, very kidogo money. So I think we also need to look at the country's circumstances and materiality, and also the context in which you operate. We are basically a cash-based economy. So as Mr. Daudi had said, some of these obligations should not be cut and paste, because it's not a one-size-fits-all. I strongly believe that we'll be able to argue that as much as probably that will give us a low rating, but we'll also have to demonstrate that we've we've put into place measures to deal with any risk that might emanate beyond the sectors that we think are infringed by the stringent and the strict application of the 10,000 equivalent rule. On the second question as to why only are we extending this to the legal profession, a journey of 1,000 miles starts with one step. And Mr. Moroga has just mentioned the whole issue of having an analysis and an assessment. And just maybe I'll come to that later. I'll just want to enlighten the members who are on board that we have actually carried out a national risk assessment. We started that process last year. Because of COVID, we were not able to finish by 31st of December, in which we were supposed to have completed. We requested for an extension of that exercise to 31st of March. We were not able, and we got a final extension of 30th June. I can confidently report that we've done that assessment across all the sectors, including casinos, including motor vehicle dealers. LSK was fully represented in this process for a couple of almost close 1.5 years. And we had to give ratings to each sector in terms of what are the vulnerabilities. Unfortunately, out of that assessment, it was a data-driven assessment. We realized that the legal profession is a high-risk profession, not because lawyers are involved in criminality. No, that I have to put that right there, and a caveat to that. It's just basically because we don't have a regulatory framework within LSK and a legal framework within the country to ensure that certain requirements are enforced, just to make sure that we get obligations which are international in nature, because we don't live in an island. I mean, this is a global village. Lawyers in Kenya are transacting on behalf of clients who are in Europe, clients in Asia. And by and large, the vulnerabilities that go through the profession are very high, and this is what is giving the rating to be high. So again, it's an issue of us identifying sectors that we think we need to protect them. And the legal profession for sure cuts across everything we do in any country. And that's why we think for us, we need to safeguard our profession from abuse or protective vulnerabilities that are related to criminals. So as we look at the other sectors, the motor vehicle, second-hand motor vehicle dealership is also a high risk. And we are just about to release the public version of that assessment. And again, the confidential version that looks at the nitty-gritties, the data, will be provided to all those who participated in that exercise, including LSK. So I'm very sure that the leadership of the LSK, once you've done with your internal processes, the same will be shared with the membership. So thank you very much, convener.
Thank you very much. Of course, the question also went to the issue of what Ms. Kasoa did mention is there are all these other people, KRA, planners, land planners, estate agents, M-Pesa. I think M-Pesa are reporting agencies, registrars of land, and all those people. What is the role of government lawyers and state counsel in terms of these reporting obligations? Probably you can just finish up on that.
Sure. I think we also need to look at section 44 in regard to the reporting obligations. What is this that need to be reported? It's basically suspicion, and the suspicion revolves around the profile of a client. And profile, by lack of a better word, is basically who you are. So if you're transacting with a bank, this is basically the practice right now. If Saitoti Maika is the DGFRC, I've declared to the bank that this is my personal account, and the funds into this personal account will be from my employer, my salary. And it's known, I've already declared, in the forms you indicate how much is your salary, 500,000 monthly, any other allowances, probably I'll be traveling once in a while, so you'll find probably a departure from not just the allowances coming in. Then you build a profile around that. The moment that profile changes and I shift from that profile, then the bank has an obligation to ask me, what is happening? You seem to have shifted. If I'm not able to give a plausible reason as to why the profile is changing, I'm getting money that I'm very cagey to disclose a source, or even I'm disclosing a source that in the best knowledge of the bank is not making sense, that causes the bank to do a sort of a reporting. That's a red flag in itself. And then basically, this is how the reporting is being done. I think the mechanics of reporting is something that we need to fully understand to be able to appreciate what is the requirement of this reporting to FRC. But now when you're looking at government agencies, central bank, for that matter, is a supervisor under Schedule 1 of the Act. And what central bank does, anytime they're carrying out an inspection on a bank, they're even able also to pick certain non-reporting by banks. And they formally file a report to FRC saying that we did an inspection on Bank A and we realized that this happened and they did not file a report with you. That becomes a reporting from central bank. The same with CMA. When they're doing inspection on the stock brokerage, they do file reports to us that we did an inspection on this stock brokerage and we realized that this happened and they never reported to FRC. That becomes an SCR from the regulator. The same with the IRA. So what basically we are saying is the issue of incorporating LSK as a supervisor under Schedule 1 is basically to have that interface. And point to note here is that FRC does not take any action without consulting the designated supervisor for that matter. We have to be in concurrence that there was actually a breach. And if we're looking at the breaches, and that's why the Act provided for administrative action, not everything becomes criminal. I mean, if you had kept record for 5 years, and then you are coming after 7 years and you don't have the records, and there's some resemblance of more or less a footprint of you having done some due diligence on that client, I don't think the aim of the law is to be punitive. I think there must be some constructive engagement in ensuring that certain things have not been willfully, unwillingly done for that matter. So I guess this is the reason why some of those agencies like KRA, you don't find us designating them as reporting entities. But point to note, we have an information sharing framework with some of those agencies. KRA more or less reports to us certain activities by certain importers that they are not making sense. Probably what they purport to be importing or exporting does not make sense. Can't you kindly verify with your counterparts, maybe in Singapore or Hong Kong? And we do that every other day. So again, it does not necessarily mean that we have to classify everybody as reporting entities. There must be some threshold, there must be some analysis or assessment as to determine who is highly vulnerable, who is at risk to be abused by criminals. And going forward, our economy is very dynamic. If you look at businesses mutating every other day, we now have the issue of digital lenders. We don't even have a regulatory framework to deal with them. They're already posing risk. We have the whole issue of blockchain, the issue of Bitcoin. We don't have a law to deal with that, but Kenyans are dealing in Bitcoin. So it's an ongoing process. We have to keep looking at the whole spectrum of who is handling cash, who is doing what in terms of businesses. And ultimately, we'll get there. But for now, I think we are just addressing some of those traditional areas that we think for the longest, we need to address the vulnerabilities and the risks that are posed to those professions by illegal actors. Thank you.
Thank you very much, Saitoti. Most grateful for your very elaborate answer. Maybe I'll just ask Dennis, do you have anything to add on to what Mr. Saitoti has shared with us, especially from a practitioner's point of view?
Thank you, Senior and Chair. On that, from a practitioner's point of view, then what I would urge is that there is need for engagement. Even as, yes, there is that aspect of if we do not comply. And it's important to note that when the reviews are conducted, especially these reports are done by the SAMALEG and as one of the bodies, they do not always go to, they do not measure more on effectiveness. The starting point is formal compliance. So yes, we could have the law by maybe January next year. When they come, they will tick that we are compliant. But now in terms of enforcement, you find that there are other legitimate concerns, and sometimes there are room for abuse. So on my part, I will encourage that we engage with the FRC more, even beyond the conducting risk assessment. I'm glad that the chair has informed us that the risk assessment is complete, and they will soon publish a public version, which then can inform even our analysis on identifying whether the current law as it is aims at addressing a particular risk. However, also, I'll encourage that we copy the US model, where then lawyers as individual practitioners do not have a reporting obligation. This could be done, for example, by ensuring that you can only report where you did a cash transaction, or not, where you received maybe fees or money in cash. So that would mean then that lawyers who would decide to have their practice, they only be paid fees via bank, then they do not have the obligation. So those are other alternatives that can make us, that can still ensure that we as a profession still do not condone crime. And also we are able to practice as we engage further to get a more effective approach to regulation. Yeah, that is my remark, and thank you a lot, all the participants and the chair.
Thank you very much. Yes, thank you very much. Mr. Saitoti Maika, DG Financial Reporting Center. Mr. Denis Moroga, colleague in the practice and a lecturer at Moi University. I'd like to thank both of you for such an insight into the anti-money laundering reporting obligations in the proposed bill. I do believe this should be a continuous engagement, and even as we engage in it, we do have the benefit of having had other countries address this issue. Dennis has referred to countries where the obligations are there and some which are not there. Saitoti has also referred to us countries within Africa where there are those reporting obligations. And we've also seen the fears or the apprehension expressed by a practitioner, Dennis, regarding, of course, the Nicholas Opio case in Uganda, and the security aspects that revolve around reporting. The other thing which, of course, we as lawyers would also have to address is, first of all, recognize that Section 143 of the Evidence Act, whereas it provides a level of confidentiality as between law advocate and client, that confidentiality is not absolute. But also our concern as lawyers is that lawyers are people who are apprehensive being given the role of reporting on their clients, whatever reason they may be required to. So I think in the ongoing discussions, as this bill is discussed, it is something which we hope that those concerns will be addressed. Just before coming for this session, I did see or watch a clip of our colleague, Pondo Kaluma, Member of Parliament for Homa Bay, debating very vigorously and robustly about the need of having lawyers as reporting agencies. On the other hand, we also saw Amolo Tiende holding a contrary view, and also a very robust argument. And I think as lawyers, we should follow this debate so that ultimately, whatever end product we will get will be a product that we have participated in shaping. And I'd like to thank all of you for having participated, listened to us for the last 2 hours, and the questions and answers. And to our panelists, thank you very much. And with that, I would like to draw this session to a close, and not to say that it's a close on further engagement. Mr. Saitoti, I am told that you have been having an extremely open door policy, and you've been discussing this especially with the banks where there are areas of concern and all. And I believe that the same door will be open to we lawyers as and when we need to work together towards addressing this global concern of money laundering, terrorist financing, and organized crime. And with that, ladies and gentlemen, thank you very much. And I wish you all a good evening.
Thank you very much.
Thank you.
I really.